So another question here is, current experience may not be used for the green card. It's always before the current job, but a lot of people might have been working with the same company for like 6 years, 10 years as well. So there is something called progressive experience. Could you please shed some light on what it is and how it can be used?
Right. So, Ranjit, that's not progressive experience, but I understand what your question is. So you're basically asking me that suppose they don't have any previous experience. So can we then show a requirement for, say, bachelor's plus 2 years of experience? That is only possible if, for example, the experience that was gained through the petitioning employer is substantially different from the present petition. So say you have to show 50% of difference, then only you can use experience gained from the petitioning employer. Otherwise, you have to show that as of the date of joining, they already had that experience. So when we say 50% difference, let me give you an example. So you're filing for, say, a programmer analyst position. And you're asking for 2 years of experience, bachelor's plus 2 years of experience in a related field. And you say that person has worked for 2 years, but the experience has been only with the present petitioner. And say that position is that of not a programmer analyst, but something a little different. Maybe a data analyst, just for the sake of, giving you an example. So you have to show that the experience of the data analyst is at least 50% different from that of a programmer analyst, the job duties. So you have to make a table and show the differences. You have to document it clearly in the PERM. In that instance, you can then use the experience gained as a data analyst and say bachelor's plus 2 years required in the same job or in a related job, and then you can file the PERM. It is possible to do that. You want to avoid doing it if it's not necessary, but if it becomes absolutely necessary, then yes, that can be done. Another issue that comes up with the person not having any prior experience, and this is often the case with a lot of F1s, right? They join a company and then immediately they file the PERM with that company and they've not worked for any other company. When we ask for skill sets, so if we say bachelor's plus 2 years of skill, 2 years of experience in XYZ skill. If I don't ask for skill sets and I just ask for bachelor's plus 2 years of experience, everybody will have bachelor's plus 2 years of experience. So when you file the advertisement, you'll get tons of resumes. You will not be able to disqualify them, then you cannot proceed forward. The only way to proceed forward is to make sure that the duties are clearly defined and are very specific with reference to the skill set requirements. But if these skill sets were with the same employer, then it's difficult to show. So in that instance, I can say that instead of saying 2 years of experience in XYZ skill, I can say knowledge of XYZ skill. Now, knowledge can be gained through education. It doesn't have to be through experience. So that's one way of overcoming the lack of experience, previous lack of experience. So you could have had a certification in XYZ skills. So I can say certification required. Or you could have done those XYZ skills in your when you were doing your bachelor's, and you can show it that way. But remember, the certification should have been obtained before they joined the petitioner, not after they joined the petitioner. So this is another way of still showing skill sets as a requirement, even in the instance where the beneficiary does not have previous experience.
Got it. Another case is where, people have lots of experience, but earlier in the days, people only did 3-year degree. So, how to handle that? Let's say the candidate has like 20-25 years of experience in the IT, but has only a diploma or a degree, like a 3-year degree. Can a green card be filed at all in any of the categories? If so, what category do they come under?
That's a good question. Yes, there are many instances in which the 4-year bachelor's degree is not there, because if they have an engineering degree, then even from India, then it's always a 4-year degree. But for example, if they have a BSc in computer science, then it's not a 4-year degree, it's a 3-year degree. And if you then say, without realizing it, that bachelor's plus 2 years is required, that I-140 is going to get denied. And then there's no purpose in refiling it. You'll have to refile the labor and change, update the requirements, revise the requirements. So in the instance where they have a 3-year degree, it's not equivalent to a bachelor. So you cannot ask for, and obviously the person was hired. So that means the minimum requirement initially also was not a bachelor's. Otherwise they couldn't have been hired, because 3 years is not a bachelor's. So you should ask either for an associate's degree plus whatever, experience. So it really, how much you ask for depends on what the job title is, what is normal for the job position. If you're doing a programmer analyst, and just simply because the person has 20 years of experience, you cannot ask for 20 years of experience. So if you do, then you will get the labor cert itself will be audited. The PERM will be audited, because you're asking for requirements that is beyond the industry standard. And that is determined through the ONET, as I was talking about SVP and the code, job zone 4. Each job title has a job zone, and they say what are the minimum requirements. So if you ask for more than that, then you have to justify through business necessary document as to why you're asking for more than what the industry standard is. So in the case of our friend who doesn't have a 4-year bachelor's degree, you ask either for an associate's degree, plus experience, or you just ask for experience. Ask for 4 years of experience. If it is somebody who has an SVP of 8, such as a software engineer position or most of these IT positions, the SVP is usually 8. In that case, you can ask for maximum of 4 years of experience. So you can ask for 4 years of experience, and that's what I usually do. And then you can ask for skill set requirement. You can say XYZ skill experience required for 4 years. And in that instance, then those people will not be professionals. EB-2, EB-3, there'll be EB-3, but not EB-3 professionals, but there'll be EB-3 skilled workers. But both the EB-3s, the priority date is the same, so it really doesn't matter. So if you ask for more than 2 years, or at least 2 years, the category is 1F, which is pretty much skilled worker. Anything below a bachelor's degree. If you ask for an associate's degree also, the person becomes a skilled worker. It makes no difference really from the priority date point of view or approvability point of view. It's easier, in fact, for the case to get approved.
Got it. So how about a person who has a bachelor's 4-year but then no experience? Can they also file for a green card in the same skilled category?
Yeah, so you can file in the professional category there in EB-2 under 1E, a professional. You can file under that, not the skilled worker, because here a bachelor's degree is required. Yeah, because only a bachelor's degree is required for a professional. You don't need to put any experience at all. But the issue occurs, what happens is then, how do you disqualify the resumes that come in? Everybody has a bachelor's degree. So if you're not asking for skill sets or experience in skill sets, that's difficult to disqualify resumes. Then you'll have to do what I said earlier.
Yeah. I mean, we are talking about a situation where, as we were discussing, either masters or bachelors, people join as a fresher, and they continue they've been working probably for a couple of years or 3 or 4 years, but then, as you were saying, the current experience may not be used unless it's completely a different 50-50, whatever. So
right. So in that instance, then so to overcome that, as we discussed also, which I was going to say, is we have to show that the person has knowledge of those skills and not necessarily experience, maybe in the form of certifications, or there's still ways of doing it. So we can show it that way also. And just say bachelor's degree, no experience, knowledge of XYZ skill.
Okay. That sounds good. So yeah, other question a lot of people have is, especially for India, as well as some other countries like China and Philippines, the dates are not current. So people who have been working in the same company for about 10 years, whose I-140 was filed like before 10 years or whatever, but then they have changed lots of designations throughout their career in the last 10 years. When it was filed, probably they were a programmer or a developer, and now they are like probably a project manager or a VP or some other positions. So how to handle these situations? So can the, can the I-140 be amended, or how, what it comes in picture when especially the date becomes current, how to handle those situations?
So USCIS has consistently said that uh, a 485 can be filed even if the job duties change, as long as the change is not significant. So simply an increase in their responsibilities, as long as the skills remain the same, the increase in their responsibilities doesn't necessarily mean that the 485 will be denied. So simply because they're receiving more wages or they have a more supervisory kind of role, that is fine. You can still file the 485 without having to refile the labor and go right from from the beginning, have to start everything all over again.
Okay, that sounds good. Other situation is similar kind. Employers change their locations. Sometimes maybe within same MSA, sometimes not within the same MSA, and sometimes maybe out of state. In those situations, can they just amend the petitions, or what process need to be followed for each type of scenario?
Right. So as I discussed this before, this scenario,
Yeah,
if
for the
it is
out of
within the
states.
same, yeah, if it's within the same commuting distance, then you're fine. But if it is outside of that, then you cannot file an amendment. You have to refile, Ranjit, you have to refile the labor cert pretty much in that instance. So they're
Okay,
out of
let's say
luck.
if it's
But
just within the same state but different,
then
probably
it's
other
fine.
end
As I
of the
said, then
state.
if it's same state within
Fine,
commuting distance, then
not even an amendment is needed.
nothing is needed. You can just file the I-140 and in the cover letter, just write and say that location has changed, but it's within the same county or state or commuting distance or whatever it might be, and therefore we are filing this petition.
Okay. And going back to the previous question where the change in the designation thing, can they amend? I mean, let's say someone wants to amend because they have been promoted or whatever. Can they just amend the I-140, or do they have to
No, you
again?
cannot. You cannot, because you cannot amend the
Okay.
job title. You can remember, when you're talking about amending an I-140, you can only amend the category within which you're seeking to file, if you qualify. And that is basically between EB1, EB2, EB3. You can not even EB1, between EB2 and EB3, you can toggle when you do an amendment. Also, you can amend in situations where there's been an error. Right? There's a mistake in the I-140. Maybe you didn't include the family members. Maybe you didn't ask for the priority date to be retained. Those are situations in which an I-140 can be amended. You cannot amend to change the job title.
Okay. Yeah. Coming back to the last one you're talking about, the upgrades and downgrades. Can you just tell about what is an upgrade, what is a downgrade, and how does it work? I mean, these days it has become very common for the downgrading, especially because the EB3 dates have advanced a little bit more than that of EB2.
So in a situation where you need to downgrade, there are two ways you can do it. You could either file a new petition. In part 2, there is a column in the I-140 form in which you mention if you want to amend the petition. So an existing petition can be amended by ticking off that box and giving the previous receipt number. When you do that and you amend it, say from EB2 to EB3, you have lost your EB2 priority date or I-140 approval. Now you only have an EB3 I-140 approval once the case gets approved. If it gets denied, then of course status quo is maintained. But if you want to keep both the I-140 approvals, then what you need to do is not amend it and just file it as a new petition. And just write in the cover letter that we're filing a new petition based on the same labor cert, and we're filing this petition under the EB3 category. So then what happens is you're maintaining your EB2 I-140, you're maintaining your EB3 I-140, you have two I-140s with the same priority date. And based on which one is more conducive, you can file the 485 based on that. Say you file the 485 based on the EB-3 now because EB-3 is moving further. In the future, if the EB-2 movement is faster, then you could prospectively then inform USCIS that you would like to basically interfile your existing 485 with the EB-2 I-140. That's also possible, and they can just then maybe then your 485 will become current and it could also get approved. So this is the advantage of maintaining both, because then you could toggle between the EB-2 and EB-3 based on which visa number has become current.